Thank you for joining Jackson Lewis as we take a closer look at the employment law trends and tactics sure to shape 2023. This installment is one of 12 concise, field-specific podcast episodes that are part of our annual forecasting favorite, The Year Ahead. We invite you and others at your organization to experience the report's legislative, regulatory, and litigation insights in full at our website, jacksonlewis.com, or listen to the podcast series at whichever platform you turn to for compelling content.
Hi, this is Kathryn Russo. I'm here today with my partner, Kathryn Cano. Apparently, you need to be named Kathryn to work in our practice group. But Kathryn and I both practice in the drug testing and substance abuse group. And the topic that we get the most is marijuana. And that's what we're going to talk about today. So for 2023, employers really need to be thinking about their drug and alcohol policies and how they're going to address marijuana, because the laws have been changing. As most people know, it's been changing gradually over the last several years, but we're getting to a point now where it's no longer acceptable for employers to say, well, we're just going to handle it like it's illegal because it's still illegal at the federal level. And even though technically marijuana is still illegal at the federal level, I don't think employers can operate that way anymore. We do know that the federal government is considering legalization of marijuana. That has not happened yet. I think it will happen eventually. I don't know when. In the meantime, employers really need to think about complying with the applicable state and local laws in the locations where they operate. The courts are now enforcing those laws rather than enforcing the federal law that makes marijuana illegal. And their view is that the federal government has not enforced the law making marijuana illegal in many years. So that means we should be looking to state and local laws. So there are many, many laws. We have medical marijuana laws, recreational marijuana laws, laws that protect off-duty use, laws that prohibit certain types of drug testing for marijuana. So employers really need to get familiar with those laws and comfortable with those laws. And to make it even more complicated, marijuana testing is very complex because there are no drug tests that can detect current impairment or recent use, which makes it very hard for employers to make a decision on a positive marijuana drug test. So that's by way of an introductory background. So Kathryn, why don't you tell us, what are some of the issues or questions that we're seeing from employers?
Yeah, absolutely. So a very, very common question we get from employers is, do we need to continue to conduct marijuana testing? Sometimes this question comes up as, can we just take it off of our panel? Can we take it off certain types of tests? And the answer to that is, for most employers, yes, you don't have to test for marijuana. The exception there would be, DOT covered employers, or if you have some specific, if you're in a specific industry where you have mandatory drug testing. But for other employers, the vast majority of employers don't have any legal obligation to test. So if you don't want to test for marijuana, you typically don't have to. So another question that we're commonly getting is how employers should address CBD use and whether CBD is permissible. Back in 2018, Congress passed the Farm Bill, which legalized hemp under federal law. Hemp is basically cannabis that has 0.3% THC or less. So if you're seeing CBD products, that's why. The trouble with the CBD products is that they're really not regulated. The FDA has not approved any over-the-counter CBD products for therapeutic or medical use. So although many of those products do advertise as having medical benefits, that has not been evaluated by the FDA. So when we're looking at the situation, CBD makes it a lot more complicated because an employee theoretically could test positive for marijuana based on CBD use, and there's really no way for an employer to tell. Another common question that we're getting is how an employer should handle a situation where there's reasonable suspicion of marijuana use at work. And I would say reasonable suspicion testing is probably the most common for employers that are looking at getting rid of marijuana testing or that have gotten rid of marijuana testing. Many of them still want to keep reasonable suspicion testing, similar to how they have, alcohol covered for reasonable suspicion testing. So if you want to do reasonable suspicion marijuana testing, that is going to be legal in most jurisdictions. There's a couple where you may run into some issues, but the employer needs to look at what are the actual signs and symptoms that are justifying the test. You may want to give the employee an opportunity to respond to it. And if you're in a jurisdiction where you can't do a test, but the employee appears to be impaired, you can always focus on the employee's underlying behavior rather than the drug test. I think as marijuana issues have become more complex, I'm often telling employers, take a step back, look at the situation as a whole. Do we really need to do a drug test, or can we focus on a safety rule violation? Or if somebody's performance isn't up to par, why aren't we focusing on the performance issue? Let's leave the sticky marijuana issues on the side and just focus on the underlying conduct. So, Kathryn, what are some of the immediate compliance issues that you're seeing around marijuana?
Well, I think the first one, of course, is just going to be legal compliance. So, I always tell employers, please make sure that you have your drug and alcohol policy reviewed regularly. And it's frustrating because I think back in the old days, we used to tell clients that, we only needed to review their drug and alcohol policy maybe once every couple of years. Now I'm telling clients, you should have us look at it probably every 6 months, especially if you're in a lot of different jurisdictions, because there are just so many laws that are coming out all the time, and I'm trying to remember how many in 2022, there were probably at least 5 or 6 new state laws that came out. And that seems to be sort of a common theme every year. So I think that employers, number one, you got to make sure that your policy complies with all of the laws. You've got to know what the laws are in your jurisdiction. And then, you've got to decide, how do you want to handle marijuana? I think that's a big question now. It's not just, again, in the old days, employers just tested for it. Now I'm saying to clients when they talk to us about preparing a policy, one of the questions I now ask is, do you want to test for marijuana? Because it's complicated and, it's not just an easy, fire the person if they test positive. If you're in a state where marijuana use is protected, you've got to think about whether it makes sense. One of the trends that we're seeing is I'm seeing nationwide are that employers are discontinuing testing for marijuana on pre-employment tests. And I think the rationale for that, especially in states where recreational use is legal, is that, if it's a legal substance, then similar to alcohol, how does a positive test result help the employer make a hiring decision, right? Because the person didn't do anything illegal if it's legal in that state. If they test positive, it doesn't mean necessarily that they're an addict or they have a problem or that they'll be a bad employee. So, I'm often telling clients, think about whether you really need to test for marijuana, especially on a pre-employment test, and especially if you're in a lot of states where recreational use or off-duty use is protected. So I think those are some of the big issues. Just to kind of echo on what you said earlier, Kathryn, about CBD use, this is like a huge, huge problem for employers now. Because drug tests can't distinguish between a positive test for marijuana and a positive test for CBD. So I'm hearing more and more complaints from clients that, oh, we tested this person and they came back positive for marijuana, but now the person is saying, well, it's CBD. And that poses a lot of problems if you're in a state where there is a lawful activity law, or sometimes they say, I'm using the CBD because my doctor told me to use it for some medical condition, right? So now, even though there may be no protections for CBD use in a particular state, you've got to be thinking about disability discrimination issues, right? Because if the person's doctor said, I want you to use CBD cream for your arthritis, there's a possibility that person will test positive because the THC, even if it's a legal product with 0.3% THC or less, it will build up in the tissue, the fatty tissues of the person's body over time so that they test positive on a drug test. And it's very difficult for employers to figure out, like, well, do we believe them? How do we know the person's not lying? Maybe they are lying about the CBD use and maybe they're smoking marijuana and it's a state where it's illegal. These are really, really hard discussions and decisions for employers to make because there's no way for you to ever know whether the person is lying or not. And the drug test results don't distinguish between marijuana and CBD. So it really is extremely complicated. And I think that for some employers, they're just either, deleting marijuana from their drug test panels altogether, or they're limiting it only to reasonable suspicion tests. I do work with a lot of clients who have decided it's not helpful for a pre-employment test. It's not helpful on a random drug test. It's probably not even helpful on a post-accident test because you can't prove that the person was using marijuana at the time of the accident. So I am finding that many employers are now limiting marijuana testing to reasonable suspicion only. And if the person tests positive, as Kathryn said earlier, look at all of the circumstances, look at their impaired behaviors, and not necessarily just the positive test result, because they're going to claim that they used the marijuana when they were off duty and they didn't do it at work. And so you've got to be careful about placing too much emphasis for an employment decision on just the positive drug test result only. So I think those are really the immediate compliance issues. Really being sensitive to the laws, having a good policy, deciding whether even testing for it is really helpful to you, and then thinking about how are you going to address people who say, I need to use CBD either because it's legal under federal law or because my doctor told me I need to do it. So, Kathryn, tell us what are some some of the other broader issues that we're getting on a regular basis from clients?
Yeah, I think that there's kind of to piggyback on your comments about eliminating marijuana from the panel. A common question that I get is, are we creating liability for ourselves? What if somebody gets hurt? What if they hurt somebody else? Are we going to be facing a negligence lawsuit? And my response to that is, unless there's an actual obligation to test for marijuana, that's probably not going to be a significant risk in most states. I mean, to be able to show that you're negligent, an employee would have to, or a third party would need to establish that you had a duty, that you breached that duty. And again, without there being an obligation to test for marijuana, it would be difficult to show that there's any sort of duty to do that. I think also when you're in a state where marijuana is legal, people can be, somebody who uses marijuana off duty could be driving cars. I mean, engaging in normal day-to-day life. So the risk that somebody might have at work is probably not that different from what risks they would just encounter out in the public if they're in a state where recreational marijuana is legal. Another just kind of wrap up point. I know, Kathryn, you mentioned at the beginning that we think that it's just a matter of when, not whether, there's going to be federal legalization of marijuana. And for some employers, I think they're hoping that this is going to be the kind of the silver lining. We'll get some guidance, we'll get some direction, and this won't be such a mess. We won't have to ask the Kathryns to update our drug policy every 6 months because of marijuana changes. But unfortunately, I think we're not expecting Congress to give us all of the answers on this. What's more likely is that they'll kick the issues back to the states, just like they did with CBD. So with CBD, they legalized it, or they descheduled it. They took it off of the Controlled Substances Act and allowed states to have stricter laws, but they didn't give any real direction. So the likely effect of federal legalization when that comes to fruition is that we're still going to have to deal with the state mess. And then we're also going to potentially have additional ADA issues to consider, which we've been able to avoid just based on how the ADA is drafted.
I agree with you. The one other point I wanted to make, what you said earlier about the whether or not employers should continue to test and whether there are going to be safety issues. Sometimes employers will say to me, well, why should we stop testing for marijuana on a pre-employment test? Isn't that negligent? Like, isn't it negligent hiring if we don't do marijuana testing? And, I always say no. Like, as you said, unless the testing is required under federal law, like for a DOT position, most employers are not required to do pre-employment drug testing. So I don't think that there's any negligence there in not testing for marijuana. You can still test for all the other drugs, but especially if you're in a state where it's legal, I don't think that a pre-employment test for marijuana is really that useful. right? So I think a lot of employers have concerns that, and I think it's just because of so many years of treating marijuana like an illegal drug, and it's hard to change your thought process, right? It's hard to start thinking about marijuana now as something closer to alcohol rather than an illegal drug. And so I've been, discussing with a lot of clients. I think it's time to, really change your thought process around it, because I agree with you that it doesn't really prove that much that's helpful to an employment decision in either a pre-employment scenario or a random, and potentially even a post-accident test. So, I do agree with you on that. And as far as, what's the end result? I do think that employers should really think about, where do they want to be? Like Kathryn said, it's only a matter of when, not if, it's going to be legalized at the federal level. And you're going to have to start complying with these state laws anyway. So if you're an employer who hasn't yet started, getting familiar with the state and local laws where you operate, I think it's time to do that, because, even though the legalization at the federal level hasn't happened yet, it is coming, and the courts are already saying it's time to start, complying with state and local laws with regard to marijuana.
Well, Kathryn, thanks for joining us this morning and sharing your wisdom here. It's always nice to bounce ideas off of our team of Jackson Lewis experts here. And thank you, everyone, for listening. I'm sure this is an area where we will continue to have updates. We regularly post about changes to marijuana laws and drug testing laws on the Jackson Lewis Substance Abuse Advisor blog. So you can always look for updates there.
Thank you for joining us for the Year Ahead 2023 Special Edition podcast series. Please tune in to the next episode where we will continue to tell you not only what's legal, but what is effective. All of our Jackson Lewis podcasts are available to stream and subscribe on Apple Podcasts, Google Podcasts, Libsyn, Pandora, SoundCloud, Spotify, Stitcher, and YouTube. For more information on today's topic, our presenters, and other Jackson Lewis resources, visit jacksonlewis.com. As a reminder, this material is provided for informational purposes only. It is not intended to constitute legal advice, nor does it create a client-lawyer relationship between Jackson Lewis and any recipient.